So the procedural issues were essentially that it didn't cite any authority, although it does, I believe, cite ORCP 47 in at least one spot. It may not be, frankly, the right spot, but it's close enough for my purposes. There's some question about the signature on that motion, and I'm trying to pull that motion up. Far too many motions to keep track of them all. I think the issue there, no, both of those are signed. That's not one of those that has the issue. There were some of the pleadings that Mr. Dyke filed that were only signed following the certificate of service. This isn't one of them, but I haven't addressed that issue. I think the more conventional way to sign a pleading is as he's done for this motion, which is under the motion itself and then under the certificate of service. But given the number of them that are signed that way, I would certainly require that I would find that if appropriate, Mr. Dyke were subject to ORCP 17 for having signed the pleading. It's clearly intended to submit that and sign it, and did. So whether it's got one signature or two, I don't think that's a reason to not consider his motion. Anyway, getting back to where I was going. With regard to that motion, it does require, ORCP 47 that is, which is cited in that motion, does require an adverse party, defendants in this case, to file opposing affidavits or declarations and supporting documents within 20 days of the day they were served with the motion. That said, ORCP 7 gives the court the discretion to modify the times to respond to a motion for summary judgment. The defendants requested their continuance within the original time frame of ORCP 47 and requested it based on a variety of discovery purposes and the raising of the assignment issue. The assignment claim, or the assigning of the Mears claim to Mr. Byers. Yes, I believe I got all the parties in the right order on that. From my review of the case, and I could be incorrect, but from my review of the case, it's first mentioned in the motion for summary judgment. It's certainly not the original complaint. It's not the demand letter that started the claim. And if we are, in fact, proceeding on this assigned claim, I'm having a real difficult time finding why I wouldn't continue and expand that time for the defendants to respond to the motion for summary judgment. I think they're entitled to perform additional discovery. I think they're entitled to research that issue about whether or not assignment is possible, whether it's valid, what impact that might have on the case, etc. I also frankly think plaintiff is going to need to either amend or supplement their complaint, and that needs to be done before we get to the summary judgment here. I don't see any other way to proceed at this point. Mr. Judge?
Will we have an opportunity to discuss those assignment agreements today?
Probably not as much as you want. For a couple of reasons, because again, I'm not in a position where I can make any sort of evidentiary determination, and there's really not a motion where I can deal with that except for the motion to supplement, which I'm leaning towards not prepared to deal with today, given how quickly, how recently it's been filed. You haven't had a chance to respond to it. And I've only had a very minimal amount of time to research it, and frankly, it's kind of a complex issue. At least it appears that way to me. It may be that I find something that makes me change my mind on whether it's complex or not, but at the moment it appears. So I would grant that motion. I'm not going to set a definite timeline at this point because we've got some other things we need to resolve, including the motion to supplement the third claim for the first amended complaint. and the defendant's motion to resolve the discovery impasse. I know you requested someone other than Mr. Tissot. It's not my intention to resolve that motion that way, but I have a different idea. So here's what I think we need to do to move forward on those motions that we haven't resolved today, which include the motion to supplement the third claim. We need to set a time to have that hearing. Typically, Mr. Beck, you have 14 days to respond to that motion, assuming you would like to do so. And I believe it was filed yesterday. So 14 days from that would put us at the 9th. Mr. Tissot were to take his full 5 days to reply. That gets us to the 16th, which means the first date we could have a hearing would be the 17th. Let's see what we've got. And that gets us into the week of Christmas. Nobody wants to probably do this that week.
Your Honor, we don't mind that.
Mr. Tissot, are you in the office that week?
I am.
Friday the 27th work?
We'll be out of town.
Okay. Could do it Thursday the 26th.
We'll be out of town.
Okay, so that week does work somehow. Let's move into the next week. No, we're not doing it that day. I could do it at 4 o'clock on January 8th. Do we already have hearing settlements on the 8th?
We do.
Yeah.
Well, why don't we just do it then? I think that's what we're going to have to do. Which means that we won't be doing our summary judgment on the 8th. We'll be dealing with the motion to supplement. And I might as well put some cards on the table on that motion with what I've got so far, just so people know what my concerns are, and maybe that can help speed us along. I'm concerned first about whether it's appropriate to supplement that pleading or amend that pleading. Meaning, which of those avenues should we take, not whether or not it's appropriate to do either. I'm also concerned about whether it's appropriate to do either. Part of that relates to whether or not this is the type of claim that can be assigned. Assuming it is a claim that can be assigned, does the assignment after the filing of the initial complaint have any impact? Mr. Dyke? Well, I'm trying to think if I have a fifth issue.
Yeah, we're perplexed in that the renters have made no claim against us. They haven't sent any demand letter. They never called us and said, could you please do this or that? You know?
I understand. And
How can you assign claims when there are none?
I think there might be a fundamental difference of opinion about whether or not there's a claim.
They haven't pulled any damages out of their imagination to assert against us.
Assuming we are dealing with an assigned claim, it would be the damages suffered by tenants, and that would be an issue we need to figure out at some point in the suit. So that's the first date we need. Second date, I think, would be appropriate in a way to attempt to resolve the discovery stuff, which there's a fair amount of, and I'm not going to point fingers because that's not going to be productive. But I'd like to get that done, or at least as done as we can, so that we can move forward towards getting a summary judgment, which could resolve the case, or getting it set for trial, which obviously will resolve the case. Mr. Dyke.
Since the 14th until yesterday, plaintiff's counsel was utterly unresponsive, other than to confirm that his computer was still working. So
Again, I'm not going to point fingers or cast blame at this point. What I would like to see.
Your Honor, maybe I can expedite this a little bit. As far as inspecting original documents, the only original document I have is the settlement agreement between Mears and buyers. Now I have it here. That's the only thing that I have, and maybe he can just inspect it right now and make a photocopy, and we'll be done with that.
Does your client possess any originals?
Well, so part of the issue that, I'm trying to make is Mr. Duck has never told us what originals he would like to see, and I keep asking him for the list. And his response is, well, just refer to the RFPs. I don't think that's conferring in good faith. I've told him, of course, there's no originals to emails, right? I don't know how to produce an original email. The only thing I know what to do is print it. And I've printed it and I've submitted it to Mr. Duck, and so I don't know what else there is to do. The one original I have in my file, and he's welcome to look at it right now.
Your Honor, we've never disputed emails. This is
So ignoring the emails, are there particular documents that you want to see the originals of?
I want to see the original, the permission to use letter that this attorney scratched through and refused. I want to see the originals of the envelopes that were returned to his office. I want to see if it's available to lease.
And it sounds like that's not. Is that accurate?
After diligent search, we
No
have not
originals.
found.
Okay, so it's not there.
Obviously, there's a source for where the lease came from.
Well, it could be a copy. I mean, it's possible that there was an original.
Were the Mears asked if they have it? How would renters not have it? How about the copy that they have?
That poses another issue. If this isn't a signed claim, whether Mr. Byers is obligated to produce documents in their possession.
We have no control over the mirrors.
Might create some issues if this isn't a signed claim. So, Mr. Bick, what I'm going to ask you to do, it sounds like it's a relatively short list of those items you want to inspect the originals of. If you could create that list, provide that to Mr. Tissot. Try and schedule a time when those documents can be inspected and copied. I don't care where you folks do that. If that doesn't work, it would be my intention to schedule effectively a discovery conference where the two of you show up, bring whatever other documents we've got to deal with, and get it just taken care of. Mary, can you block out the rest of the morning of the 8th? So until noon. And then hopefully we can use that if we need to address those issues, Mr. Wright.
It has long been established that certain things should be forthcoming. We don't want to get into an argument about if we present a list, we have to go, do what he should be able to find out from the previous council. On the 19th, it was decided that utility bills would be forthcoming.
Sure,
She disappeared, and now he's ignorant of it, and like we're starting all over again.
And anything that I previously ordered to be produced should be produced. I don't have any dispute about that.
Your Honor, may I address the utility bill? Mr. Myers doesn't have any utility bills for that period, and I've let Mr. Duck know that.
Okay, so those.
I don't recall that, Your Honor.
So, well, it's done now, so those are no longer an issue.
No,
But this is what I want to do, I want to set that 8, we're at 10:45, we'll deal with the motion to supplement. We will immediately after that attempt to work through any remaining discovery issues. Again, get a list of the documents you want to see the originals of to Mr. Tissot. If there are any other documents you feel you need to request, get that request in immediately so we can have those addressed that day. And at that conference, depending on how we proceed with regard to the supplement motion, we'll figure out our date for summary judgment responses to be in and a date for that hearing. Mr. Dunn?
are you saying that they don't have any obligation to do anything between now and then?
No, I'm not saying that. What I'm saying is on the 8th, we're going to try and resolve any outstanding disputes.
Well, their 30 days will be up on, coming right up on a number of discovery requests.
So to the extent that those documents exist, that it's appropriate to produce them, they need to be produced.
So I will have to do a whole batch of motions to compel between now and then.
If they haven't produced them, that will be the appropriate step. I'm hoping that they would produce them or respond appropriately if they don't exist, that they do exist, and here they are, whatever the appropriate response is. I would hope that they would do that. So that by the 8th, we can address all the discovery issues, because the only way we're going to get this case resolved is to have those discovery issues resolved so that we can move forward. Go ahead.
We don't want to have to wait. I mean, the longer we wait, the harder it is for us to respond. I mean, if we have to wait till the 8th to see what we think is a specious assignment agreement, that we don't really like that.
I appreciate that. I'm not saying you have to wait until then. What I'm asking you to do is provide a list of the original documents that you want to see. Get that to Mr. Tissot. That the two of you try and work, hang on, you gotta listen before you can object. That the two of you try and work out a time when you can inspect those and copy them if you wish. I'm also requesting that Mr. Tissot respond appropriately to your discovery requests that are currently outstanding. Whether that is a response that says we don't have them, they don't exist, we've got them and here they are, whatever the appropriate response is.
And objections as well.
If appropriate, certainly. And if you have filed motions to compel, we'll address those on the 8th. If there are other discovery issues that I can help push towards a resolution, we'll try and do that on the 8th. My intention would be that we resolve as much of the discovery as we can so that we can set that motion for summary judgment hearing and set a time for you to file your declarations and affidavits in response to their motion.
So there will be no opportunity to inspect any original documents between now and then.
What I'm asking you to do is prepare a list of the original documents that you want to see. That's step 1. Step 2, get that list to Mr. Tissot. Step 3, you and Mr. Tissot attempt to find a time when you can do that at a location that you can mutually agree to. That's your opportunity before the 8th.
Your Honor.
If you're unable to do that, we'll do it on the 8th.
Your Honor, we have filed perjury charges with the DA against this attorney. We do not feel comfortable having to meet with him. I have proposed his Heather and my Heather. Maybe they could meet at Staples and do some of this. We want an alternate arrangement.
I appreciate that. That's not typically done, and I don't see a reason to do it in this case. I assume you both can act like grown-ups.
It's not fair to subject a public venue to what might happen.
I would imagine what would happen is that you
Your
honor
Honor.
the paperwork and you copy the paperwork. There
This is
doesn't,
the
there
kind
doesn't
of-
need to be any discussion between the two of you. It's that simple. And if you're not able to do it, we'll do it on the 8th. And I'll supervise. In open court, with the authority to hold either of you in contempt and send you to jail if appropriate.
Your Honor, I'd like to state a few things. Mr. Doug makes these kind of veiled threats that something's
Objection.
going to happen.
Objection.
I take great offense to that, and I think he should be admonished not to that he has to behave himself.
Look, I always expect everyone appearing in the courtroom to act like grown-ups. I expect when you're dealing with each other, you act like grown-ups. It shouldn't be that difficult. It really shouldn't. It's apparent that the two sides aren't going to resolve their dispute working together. That's fine. That's what we're here for. So there's no need for the two of you to discuss the issues while you're going over the discovery. You inspect and copy what's produced. If you've got an issue with what's produced, whether it's because something wasn't produced that you think should be, or you think that what was produced isn't the right thing, you're welcome to bring that issue to court. It doesn't sound like the two of you are going to work that out face to face. I would encourage you to confer about those issues by email, because that seems to be a much better way than face to face. That would be my directive.
I mainly don't trust myself. After a year and a half of this, there's a lot of hostility and anger. I don't trust myself
Well, Mr. Dr.
in a public venue to be the
Oh.
peaceable person you would like me to be.
If you can't trust yourself to be that peaceable person, maybe we just need to do it on the 8th. Okay, thank you all very much. We're in recess.